All right, so welcome. We're going to be diving into a case from Bermuda, using excerpts from the actual court judgment. So this has been the deep dive.
It has.
Thanks for listening.
And thanks for having me.
We'll see you next time.
In this podcast, there could be mistakes, so please check the source material. Enjoy exploring and have a great day.
The content of this podcast is for informational and educational purposes only. It is not intended as legal advice and should not be relied upon as such. While efforts are made to ensure accuracy, the information discussed may not reflect the most current legal developments and is subject to change. For advice on specific legal issues, consult a qualified attorney licensed in your jurisdiction. The opinions expressed are those of the hosts and guests and do not necessarily reflect the views of any organizations they are affiliated with. By watching this video, you acknowledge and agree to this disclaimer.
Welcome to the deep dive. Today, we're diving into something that might not sound as glamorous as our usual topics, but trust me, it's essential knowledge for anyone living in the digital age. We're talking about Bermuda's Personal Information Protection Act of 2016. Imagine a world where your online data is treated with the same care as your physical possessions. That's what this act sets out to do, and we're going to unpack exactly how it works.
You know, it's fascinating how much data we generate just by going about our daily lives. From online shopping to fitness trackers, it's all being collected and stored somewhere. This act is Bermuda's way of ensuring that organizations handle that information responsibly.
Okay, so let's start with the basics. What exactly is considered personal information under this act? We're talking about more than just your name and address.
Right, absolutely. The act casts a wide net. Think fingerprints for gym memberships, genetic data from those trendy DNA testing kits, even your online posts expressing opinions or beliefs. It's all considered personal information.
Wow. Even my rants about the latest internet drama, that's pretty surprising.
Precisely. And that means your local gym can't just store your fingerprint data without your explicit permission. Those DNA testing companies need to be crystal clear about how they're using your genetic information. And even those online platforms you use for your rants need to handle your data responsibly.
So this act covers a lot of ground. But are there any situations where it doesn't apply? What about information I share with friends and family, like personal photos or messages?
Good point. The act focuses on how organizations handle your data. So personal use is generally exempt. If you're keeping old family photos in your attic, that wouldn't fall under this act. It's all about striking a balance between protecting your privacy and allowing everyday life to function.
That brings us to a really important point. The act specifically lists some exceptions where it might not apply.
Yes. One of the most interesting exceptions is for anything related to freedom of expression. Let's say someone's writing a book about you or creating a piece of art that features you. This act might not apply in those situations.
But wouldn't that make it hard for individuals to protect their privacy if someone chooses to write a scathing expose about them?
It's definitely a delicate balance. The act tries to safeguard free speech while also ensuring that personal information isn't exploited. It recognizes that context matters and aims to prevent the act from being used to stifle legitimate expression.
That makes sense. What about business contact information? If I give my work email to a potential client, are they free to use that for marketing purposes?
Here's the distinction. If they're using your email for legitimate business communication, that's generally fine. But if they start bombarding you with marketing emails that you never signed up for, that's a different story. The act still provides some protection against those unwanted solicitations.
Okay, so unsolicited marketing emails are a no-no. What other exceptions should we know about?
Another fascinating exception is for archival institutions. Think museums, libraries, historical societies. They often hold personal information. That's incredibly old, potentially even centuries-old records.
You know, I always find it fascinating to think about the stories those old records hold. But what about the privacy of the people mentioned in those documents?
Right, it's a valid concern. The Act recognizes the unique role these institutions play in preserving our history. So there are special provisions that apply to them, generally. It's okay for them to keep these records, but there are strict rules about how they can access and use the information. It can't just be thrown open to the public. They need to take steps to protect its confidentiality and only use it for legitimate research or archival purposes.
That makes sense. It's like acknowledging the historical significance of the information while still being mindful of the privacy of the individuals involved.
Exactly. And that idea of balancing competing interests is a recurring theme throughout this entire act.
Okay. Here's something that caught my eye, and I bet it'll surprise our listeners. The Act doesn't automatically override any pre-existing agreements you might have about how your information can be used. So, that contract you signed a decade ago for an online service, it might still affect how that company can use your data today, even if this act came into effect later.
You're absolutely right. This is why it's so crucial to read the fine print, especially when it comes to agreements involving your personal information. You never know how those terms might come back into play years down the line.
So, even with these new laws in place, your past decisions can still impact your privacy. It's a powerful reminder to be proactive and informed about how our data is being used.
Precisely. And on that note, it's important to remember that this act doesn't exist in a vacuum. It's part of a larger legal landscape, working in concert with other laws to protect your rights.
Right. We focused on the Personal Information Protection Act, but it's not the only piece of legislation. Protecting individuals in Bermuda.
Exactly. The act specifically states that it aligns with other relevant laws in Bermuda, such as the Human Rights Act of 1981.
So it's all about creating a consistent and comprehensive legal framework to protect your rights, ensuring there are no loopholes or contradictions when it comes to personal information.
That's the goal. This consistency is crucial for both individuals and organizations, helping to create a clear and predictable environment for everyone involved.
This has been a fascinating look at the foundation of Bermuda's Personal Information Protection Act. We've covered a lot of ground, from the broad definition of personal information to the Act's scope. And those intriguing exceptions, what are your key takeaways so far?
For me, it's the Act's emphasis on balance. It attempts to protect individual privacy while acknowledging the needs of organizations, freedom of expression, and historical preservation. It's a nuanced approach, which is essential in such a complex area. And of course, the crucial reminder to always read the fine print. Those old agreements can still have an impact on your privacy, even in today's data-driven world. We'll be back in part 2 to explore even more aspects of this fascinating act. Welcome back
Back to our deep dive
into Bermuda's Personal Information Protection Act,
of 2016.
picking up right where we left off.
Explorer.
The ways this act aims to protect your personal information.
In the previous segment,
We talked about the broad definition
your
of
personal information,
those intriguing exceptions
in how even old agreements
can still impact your privacy today.
Right.
Like how the act might not apply if someone's writing a tell-all book about you.
or if your information is tucked away in some historical archive.
Exactly.
Stop.
Let's get to the heart of the matter.
What rights and protections does this act actually give you?
As an individual,
It's not just about setting rules for organizations.
it's about empowering you.
to take control of your own data.
Okay.
So let's say I'm curious about,
What information a company holds about me.
do I have any right to find out
You absolutely do.
under this act
You have the right to request access.
to any personal information an organization holds about you?
You can ask them to confirm
Whether they even have your information
what they're using it for.
and who they've shared it with. It's like a peek behind the curtain.
I can finally see how companies are using my data.
Yeah.
That's a great way to put it.
Transparency is a key principle of this act.
It's about empowering individuals.
And holding organizations accountable.
Yeah.
What if the information they have about me is wrong?
Like, what if they have my old address?
Or a misspelled name?
Can I do anything about that?
You certainly can.
That's where the right to rectification comes in.
If you spot any errors in your personal information,
You have the right to demand that the organization corrects it.
you shouldn't be stuck with outdated or inaccurate information.
Floating around out there.
That makes sense.
Yeah.
What about information that's no longer relevant?
Let's say I close an account with a company.
Can I ask them to delete all my information?
That's where the right to be forgotten comes in.
Also known as the right to erasure.
This is a powerful tool.
That allows you to request that an organization completely delete your personal information.
Under certain circumstances.
This is a right to be forgotten.
That sounds almost poetic. What are these certain circumstances?
How long can I use this right?
There are a few scenarios.
Where you might be able to exercise this right.
For instance,
If the information is no longer necessary.
for the reason it was originally collected.
Or
If you withdraw your consent for the company to use it.
it's about giving individuals more control over their digital footprint.
Yeah.
If I'm no longer a customer,
Or if I change my mind about how a company can use my data.
I can potentially ask them to hit the delete button on all my information.
That's a pretty significant shift in power.
It is.
The Personal Information Protection Act is really pushing for greater individual control.
And data transparency.
Okay.
So we've got the right to access,
The right to rectification.
then the right to be forgot.
Are there any other rights I should know about?
Yes.
There's one more important right?
The right to restrict processing
This allows you to set boundaries,
for how an organization uses your information.
restrict processing,
So it's like putting up a fence around my data.
and saying,
You can only use it for this specific purpose.
that's a great analogy.
For example,
You might agree to let a company store your information.
but you don't want them to use it for marketing purposes.
This right gives you the power
To make those distinctions.
and limit how your data is used.
Okay.
All of this is starting to make sense. How does the Act actually ensure that organizations are playing by the rules?
Who's keeping them in check?
That's where the Privacy Commissioner comes in
This independent authority oversees the act.
and investigates any complaints.
It's like having a dedicated watchdog for your data privacy.
So
If I believe a company is mishandling my information,
I can go straight to the Privacy Commissioner.
what can they actually do?
Exactly.
You can file a complaint with the commissioner.
If you believe your rights have been violated,
They have the power to investigate those complaints
issue guidance to organizations to keep them on the right track.
and even impose penalties.
If a company fails to comply with the Act,
They are serious about protecting your data.
that's reassuring to know.
It's not just a set of rules written on paper.
There's a system in place to make sure those rules are actually being followed.
That's the key.
Accountability is essential for any law to be effective. But the Act doesn't just focus on punishing bad behavior.
It also encourages organizations to proactively adopt good practices,
On the outset,
baking privacy into their very DNA.
so to speak.
Baking privacy into their DNA.
What do you mean by that?
The Act promotes the idea of privacy by design.
This means organizations should think about privacy at every stage of their operations,
Not just as an afterthought,
from the initial design of their system
to how they collect.
and use personal information.
Privacy needs to be a core consideration. It's not just about fixing problems after they arise.
It's about building privacy protections into the very foundation
Of how a company operates.
Right.
A much more proactive approach.
to data protection.
Okay.
So we've talked about an individual's rights under the Act,
And how the Privacy Commissioner enforces those rights.
but what about the responsibilities of organizations?
What are some of the key things they need to do to comply with this act?
There are several important obligations outlined in the Act.
First and foremost,
Organizations need to have a lawful basis.
for collecting and using personal information in the first place.
They can't just gather your data without a valid reason. It's not a free-for-all data grab.
What constitutes a lawful basis in this context? There are a few ways an organization can establish a lawful basis.
The most common is obtaining your consent
For example,
when you sign up for a website or service.
and actively agree to their terms and conditions.
You're giving them consent to collect and use your data.
In the ways they've outlined,
Yeah.
those I agree checkboxes actually matter.
They absolutely do. It's not just about collecting the information.
It's also about how they use it.
Remember the right to restrict processing we talked about earlier.
Organizations need to respect those boundaries.
They can't just use information for any purpose they desire.
They need a legitimate reason.
It aligns with the individual's expectations.
And the original purpose for which the data was collected.
Okay.
So consent is key.
And organizations need to be clear about why they need the information.
And how they'll use it.
What else is on their to-do list
Data security.
is another big one.
Organizations have a duty to protect the personal information they hold.
From unauthorized access,
Yeah.
disclosure,
Alter.
or destruction.
They need to take proactive steps to safeguard your data. They can't just stick my information in a flimsy filing cabinet.
Or leave it unprotected on a random server.
Definitely not.
We're talking about strong passwords
Encrypting sensitive information.
and having robust procedures in place to detect and respond to any data breaches.
Makes sense.
Data breaches are a major concern these days,
Companies are constantly being targeted.
and our personal information is at risk. So, what happens if a company does experience a breach?
What's the protocol?
The Act addresses that directly
Organizations are required to report any data breaches
to both the Privacy Commissioner.
and the individuals whose information may have been compromised.
So,
If my information is caught up in a data breach,
I have a right to know about it.
absolutely.
This transparency is essential,
It allows individuals to take steps to protect themselves
like changing passwords.
or monitoring their credit reports.
Okay.
We've covered a lot of ground here.
From individual rights to organizational responsibilities.
It seems like this act is really trying to create a balanced and robust framework for data protection.
That's a great observation.
It's a complex issue,
And the Act offers a framework for navigating that complexity.
ensuring that both individuals and organizations
Understand their rights and obligations.
in this evolving digital landscape
And that brings us to the end of part 2.
of our deep dive. Welcome back to the Dim Dive. We're wrapping up our exploration of Bermuda's Personal Information Protection Act of 2016. It's been a journey, but hopefully you're feeling more empowered and informed about how your data is protected.
We've delved deep into the Act's definitions, scope, exceptions, individual rights, and organizational responsibilities. It's a comprehensive piece of legislation that reflects the growing global concern about data privacy.
Right. We've talked about everything from that fascinating right to be forgotten to the importance of data security and building privacy into the DNA of organizations. But as we zoom out, how does Bermuda's Act fit into the bigger picture? Is it a sign of a global shift in how we think about data privacy?
Absolutely. We're seeing a wave of new laws and regulations emerging worldwide as countries recognize the need to protect personal information. In our increasingly digital world, Bermuda is part of a growing trend towards a more privacy-conscious future.
Is there a particular law or regulation that stands out as a model for others?
The European Union's General Data Protection Regulation, GDPR, has been a game changer. It's set a global standard for data privacy, and many countries, including Bermuda, have drawn inspiration from it when crafting their own legislation.
The GDPR is like the gold standard. What makes it so special?
It's incredibly comprehensive and enforceable, with real teeth to penalize organizations that don't comply. But most importantly, it puts individuals firmly in control of their personal information. It grants a wide range of rights, like the right to access, rectification, erasure, and even data portability.
Data portability. I haven't heard that term before. What does it mean?
Imagine you're switching banks in the past. Transferring all your data from one bank to another could be a nightmare. But with data portability, you have the right to receive your data from one organization in a usable format, making it easy to transfer it to another.
It's like taking your data with you wherever you go digitally. That's a pretty powerful concept.
It is. It's about empowering individuals and shifting the balance of power. When it comes to personal information, for too long, individuals have felt powerless. In the face of massive data collection by companies and organizations, these laws aim to level the playing field.
But it's not just about laws.
Right.
Technology is also playing a huge role in shaping the future of data privacy. What are some of the innovations on the horizon that could further enhance our privacy?
There are some truly exciting developments emerging. One that has the potential to revolutionize data privacy is privacy-enhancing computation. This allows data to be analyzed and used for valuable insights without actually revealing the underlying personal information.
We can still benefit from data-driven innovations without compromising individual privacy. That sounds almost too good to be true.
It's a rapidly evolving field, but the possibilities are incredibly promising. And there are other fascinating advancements, like decentralized identity, which gives individuals more control over their digital identities and how their data is shared. It's like having a personal data vault. That you control, granting access only when and how you choose.
Wow. It seems like we're at a turning point in the evolution of data privacy. We're moving beyond just reacting to privacy violations and towards proactively building a more privacy-centric digital world.
It's an exciting time to be involved in this field. But it's crucial to remember that it's not just about technology and legislation. It's also about fostering a culture of privacy.
A culture of privacy. What does that look like in practice?
It's about creating a societal norm where privacy is valued and respected, not just as a legal requirement, but as a fundamental human right. It's about educating individuals about their rights and responsibilities when it comes to data, and encouraging organizations to adopt ethical data practices that go beyond simply complying with the law. It's a collective effort that requires participation from all stakeholders.
It's not just about governments enacting laws or tech companies developing new tools. It's about all of us making conscious choices to protect our own privacy and demand better data practices from the organizations we interact with.
Exactly. We all have a role to play in shaping the future of data privacy. That's what makes this topic so fascinating. It's not just a legal issue or a technological challenge. It's a societal conversation that we all need to be a part of.
Well said. As we conclude our deep dive into Bermuda's Personal Information Protection Act, what final thought would you leave our listener with? What's the one key takeaway they should carry forward into their digital lives?
I'd simply encourage everyone to stay informed and engaged The world of data privacy is constantly evolving, so it's crucial to be aware of your rights, the latest technological advancements, and the broader societal implications. The more we all understand and participate in this conversation, the better equipped we'll be to navigate the digital world safely and responsibly.
That's great advice. Knowledge is power, and understanding how your personal information is collected, used, and protected is absolutely essential in today's data-driven world. Thanks for joining us on this deep dive. We'll see you next time.
For another exploration of a fascinating topic.
In this podcast, there could be mistakes, so please check the source material. Enjoy exploring and have a great day.